you might have just heard some beautiful music playing in the background, and that music is a selection of some of the content from the movie On the Basis of Sex. And, you know, some of this that we're picking up the baton is coming after Ruth Bader Ginsburg. And I don't think any of us can be like her. She was her own force of nature. But what we're trying to do is we're trying to say if each of us can just do a little bit and to support women through this platform, that we can actually do something to exact change for the future. So what I would like to do is I would like to hand over to a very special lady, Betty, who's going to open our event with a acknowledgement of country.
Thanks, Natasha. As you all know, the DLA is a global organization. In fact, it's so wonderful right now that we have people joining us from all over the world for this launch, including Singapore, New Zealand, Europe, the United Kingdom, and so many more. Many of the attendees and speakers tonight, myself included, are located in Australia. In Australia, we place the focus on reconciliation and recognition that the land that we are on is not our land. It belongs to and will always belong to the first Australians and traditional custodians of country, the Aboriginal and Torres Strait Islander people. Now, to pay our respect to these traditional custodians and the continuing connection they have to this land, we will deliver an acknowledgement of country. In the spirit of reconciliation, we acknowledge that this launch is taking place from the various lands of the traditional custodians of country throughout Australia. We celebrate the diversity of all Aboriginal people and their ongoing cultures, and the connections to land, sea, and community. We pay our respect to all elders, past, present, and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people today. I'll now hand back to Natasha, who will address the agenda for this event.
Thanks, Betty. So I think you might see come through the chat is we've got people who are sharing some of the places that they're also coming from country. So please feel free in the chat to do that. Why don't we go straight to the agenda? Can you flick for that for me, please, Joni? So what we have today is we have some magnificent women who've put their hands up to speak to us and inspire us. And the first keynote will be Her Excellency, the Honourable Margaret Beazley, a groundbreaking woman who inspires. And then Anna, wow, she is also a force of nature. You'll see that, you'll hear that. And then keynote number 3 is Dr. Julia Powles. This is a woman who has such a heart and integrity for making sure that we approach the future of digitisation with that high integrity. So what we would like to do, you might see at the bottom of the screen there is a survey, and that's going to make sense over the course of, as all of this comes together over the course of the time that we're together. One of the things we would really like to do with the Digital Law Association is we want to collect data, but we don't want to collect data in a malicious way. We want to collect data that protects you and also allows us to speak for minority voices and also to speak in a more democratic way for voices. So today we've got a survey about gender, and we want to, when we speak as the Digital Law Association, we want to make sure that we can say X percentage of women or X percentage of people in the Digital Law Association think X. So that's our reason for taking survey data, and I really encourage you to all please do those surveys. Joni, can you just flick back to the video now? I'm super excited to share this video, and the reason I'm excited to share this video is because there is so many women in the last, I think we came up with this idea only a few weeks ago, maybe even 4 or 5 weeks ago, to put the Digital Law Association together. And I can't tell you what has been achieved by a bunch of ladies in their cracks and crevices of time trying to push this momentum forward. And this is one of the things they've achieved, and you cannot stop a clever woman on a mission. And I welcome you to watch the launch video of the Digital Law Association. Joni, I don't know if you can hear that.
We have no sound, guys.
Bear with us for a technical difficulty. How about we stop the video because we don't want to lose that, because the wonderful IT people behind the scenes work on how we get the sound for that. I know there is a way, and I'll just keep talking while we do that. So we have, do you want to flip to the next screen instead? Because you can't have a meeting without a technical difficulty. Next one. Okay, so these are our speakers, and I've already introduced them, but they will be with us shortly. But before that, you've just got me. So let's drop the slide deck, and if you can work out the video, that would be awesome. We can play it at the end. But we'll use this time instead to get down to business with a bit of Blythe preaching, which is my favourite thing to do because I feel very passionately about this. So some of you who know me will know that my favourite thing to do is to look in charity shops for secondhand books, and I often start talks telling people about my love for charity shops and secondhand books. And I often come across odd books that tell me strange pieces of information. And one book I came across the last couple of weeks was this beautiful book from Bill Gates called The Road Ahead, a younger Bill Gates, and he wrote this book in 1995. And I want to read to you a little excerpt from this book, because people might say that Bill Gates has been a pretty extraordinary force in technology over the last few years. And this is what Bill says as the introduction to a chapter entitled A Revolution Begins. Bill says, "I wrote my first software program when I was 13 years old. It was for playing tic-tac-toe. The computer I was using was huge and cumbersome and slow and absolutely compelling. Letting a bunch of teenagers loose on a computer was the idea of the Mothers Club at Lakeside, the private school I attended. The mothers decided that the proceeds from a rummage sale should be used to install a terminal and buy computer time for students. Letting students use a computer in the late 1960s was a pretty amazing choice at the time in Seattle, and one I'll always be grateful for." So that just blew me away, because it really impacted me to think, having been one of those women standing on the sidelines, having been a stay-at-home mum, knowing those P&C movements, knowing the women standing behind putting rummage sales together, that but for a bunch of women, we wouldn't have got all the things that Bill Gates, we wouldn't have got Microsoft, and we wouldn't have had some of those technological advances. And it also made me think that there was probably some pretty savvy women who were in that mothers group. And that segues quite nicely into my own personal story. And my own personal story is that I was a young lawyer in the early 2000s, the very early 2000s, and got to do lots of amazing things. Got to be an associate in the federal court in Australia, got to be associate in the US with Judge Posner, and then went on to have some babies and take time off and away from the law. And in that time, my confidence went very low. I never thought I'd be able to come back to the law, but I was able to work on being a human, and I was just surrounded myself with my beautiful children, lots of traveling to different countries. And I also had the privilege of hanging out with lots of very, very clever women. And when I decided to go back to the law, the women in my community put on a party. It was like a wedding in my backyard. And there was about 100 women, and they all came to my backyard, and they each brought a plate, and they covered tables with white tablecloths, and they put in bunches of flowers, and they brought their daughters, and they brought their women, and they brought the teachers, and everybody came because all the women really cared to try to send one of us back into the workforce. And I was so scared to go back to the law. So anyway, that was 5 years ago from now, and I would like to think that I have been successful in my journey in coming back into the law. But some things have been quite apparent in that time coming back into the law, that there aren't actually that many of us. And we know that there's a legal cliff that takes place, because we know that lots of women come into the law. In fact, more young women come into the law than young men, but we do tend to disappear. So it's something of a privilege, and I'll always be grateful to Herbert Smith Freehills for taking a chance on me and taking a woman who had 10 years off the law and bringing me back into the law. So in that position now, I have also had the opportunity to work with 53 lawyers across 13 different countries at Herbert Smith Freehills, and I've also got to see the spectacular work that women can do and men can do in technology and the law. And also in that position, I've also been able to see that we are at the cusp of a very significant social and corporate change in respect of technology. And I believe that everybody on this call today that is here is deeply aware that if we think that there was already a technological change that was coming through algorithmic justice, that was coming through AI, that was coming through data collection from a social front pre-COVID, that COVID, I think I read today, has accelerated digitalisation 10 years worth of digitalisation acceleration in the space of COVID. So what does that mean? What does that mean for all of us? If you have anything to do with the law, you probably deep down somewhere, and it gets lost, you probably have a heart for justice. And I know I have a heart for justice, and I know the reason I'm taking time out of my life and looking after my kids and being with my family is just as much for my sons as my daughters to say, you need an all hands on deck approach to the oncoming onslaught of technology. And that is why we have gathered together a bunch of the most insane and amazing women who I've had the privilege of working with for the last few weeks. And we have put together, with all of your help for coming in today, the Digital Law Association. So what do we want from you? What do we ask of you? I ask you to go a bit deeper and to say, what is my duty? If you're a lawyer, if you're a technologist, what is my duty to the future? And I would like to suggest that your duty to the future is to make sure that we face future challenges with all the people who are part of the onslaught. We all have to have a democratic voice as to what is going to happen. So stand behind us. If you're a man, please stand behind your women. If you're a woman and you can do a little thing to stand up, you don't have to be Ruth Bader, but you can give a little bit. So what does that look like? Unfortunately or fortunately, we can use the system to help us to promote this message. The word is getting out there. There are now documentaries, there are now movies that are coming together which are demonstrating to the general public the risks that are associated with the ownership and commercialization of tech being stuck with very small number of hands. If you are able to do something, what can you do? In this instance, what I would ask of you to do, and what my fellow DLAers would ask you to do, is just share the platform, because we know how the algorithms work. Because if you share it and you increase the numbers that we have, and we increase them, we will have a louder voice, because that's how the world works. So we want to have ridiculously large numbers. That's one. It's an easy thing for you to do. The second thing that we would like is we would like for those women who would like to go deeper, who actually have something to say, who have a deep technical expertise, who have a little technical expertise, who need to find a home for their interaction between law and tech, join one of our portfolios. They are led by amazing women. The Digital Law Association is just getting started. So we will have general elections. The people who founded it won't be the people who end it. So if you want to be a part of it in a governance structure, you'll also have an opportunity to do that. This is a global association, and I am so excited, and I'm so deeply moved by the number of you that have come today. And I'm especially deeply moved by the personal messages that have come from the men supporting what we're doing. So without further ado, if we can play the video now, let's play the video. If we can't play the video now, can I ask that we move on, Angelina, and you can tell a little bit about those portfolios. Thanks, everyone. It means so much to have you here. Hi everyone. I think we're going to try for the video. Joni, can we get the video up and running?
Unfortunately, we were having technical difficulties, so we'll keep working on those, and we
That's
may
all
come
right.
back at the end. And it's over to you, Angela. Angelina, I'll get the slides up in a few seconds.
That's all right. As Natasha very passionately put, there are many different ways you can join our association. So I'm going to speak now to members of the association and future members. So we have a number of portfolios that we would love for you to join. If you can't, that's all right. You know, any way you can help or join or participate, we'll be grateful. So I think we'll just wait for the slides. Joni, are the slides up? Okay. I think we might be having some technical difficulties with the slides. So I'm just going to keep going, and when the slides come up, it will be quite clear. So we have 6 portfolios. The governance portfolio, which is to ensure the smooth running of the DLA. I'm currently the lead until the next election. Yep, there we go. That's my name next to governance. And as Natasha was saying, what we want is to really build up the DLA for the next generation. So I'm going to be the lead until the next election, and then someone else will take my place. The partners portfolio, which is currently led by Sarah Jacobson. The purpose of that portfolio is to collaborate and partner with third parties in law and technology. The communications portfolio, led by Jenna Adamson, is to build a strong brand image for the DLA and to promote the purpose of the DLA. It's our external voice. And as you can imagine, all the current members of the partners and communications portfolios have been working extremely hard, and we're very grateful to them. The technology portfolio promotes cross-disciplinary collaboration and advances technical expertise. We have joint leads for that, Julia Powles and Jacqueline Alderson. The Black Letter portfolio, I've got a soft spot for this portfolio because it is absolutely at the intersection of law and technology. It promotes Black Letter law and it accommodates the advances in tech. And lead is Associate Professor Alex Sims. Now, probably the most important portfolio, the Ethics and Policy one, co-led by Anna Jaffe and Ariane Garside. It's to foster best practice and policy settings for emerging tech through a broad societal and public policy lens. So can I just say again, we encourage all members, future members, join a portfolio and be a part of shaping the direction of the DLA, shaping our 3-year strategy, help us promote a fairer, more inclusive and democratic voice at the intersection of law and technology. That's the portfolio slide. I'm just going to see if the video is up. Joni, is the video ready to go, or should we move to the next slide? I think the next slide.
We can do the video now.
Oh, okay, let's do the video.
Yep.
It's still not working.
Yeah.
There's still no sound.
I think it's a sign that we should stop the video and let's just try to play it. In fact, we'll try to play it later. What do you reckon? Just go on with the next bit. All right. All right, I think I'm back up again for the next slide. And this is very exciting.
So we've just started, and prior to the formal launch, we have 3 initiatives that we are working on, and we'll love to have people volunteer to help out. Joni, if we could just go to the next slide, please, with our current initiatives. I think there we are. So we will be submitting draft guidelines for Amazon's 3,236 satellites, but not the 37th, just 236. It's a lot of satellites. We are also involved in the submissions for the UK smart contracts and digital law. That's going to be interesting. It'll be fantastic. Love to have everyone on board. We also have, we'll be preparing submissions for the UNICEF policy guidance for AI for children. So that's our current 3 initiatives. That's just what we're starting with. Sky's the limit. I think instead of trying again with the video, we might go start with our speakers. If Joni, if you don't mind going to the next slide. I would like to say, look, we're so lucky at the DLA. Everyone we reached out to has been more than happy to help us. And we're privileged to have Her Excellency, the Honourable Margaret Beazley, the 39th Governor of New South Wales, and her husband, Mr. Dennis Wilson, attend our launch today. Her Excellency will be delivering our keynote address. Just briefly about Her Excellency. Prior to her appointment as Governor, Her Excellency enjoyed a long and distinguished law career spanning 43 years, during which time she served as a role model for women in law at both the state and national level. Personally, she was a role model for me when I joined the New South Wales Bar, and prior to that when I was a tip staff to Mr. Justice Hamilton. So personally, I am so pleased. I'm so excited. She is our keynote speaker. Her Excellency was appointed Queen's Counsel in 1989, made a judge of the Federal Court of Australia in 1993, the first woman to sit exclusively in that court. And in 1996, Her Excellency was the first woman appointed to the New South Wales Court of Appeal, and subsequently was the first woman to be appointed its president. Her Excellency was made a Companion of the Order of Australia in the Australia Day Honours List on 26 January 2020 for eminent service to the people of New South Wales, particularly through leadership roles in the judiciary and as a mentor to young women lawyers, me included. Your Excellency, if you could please start your keynote address. Thank you.
Unmuted, excellent. Just before doing so, what time would you like me to finish my address? It's as important as starting.
I think, Your Excellency, you can take as long as you want. I think we're aiming for about 15 minutes.
About 15 minutes. Excellent.
About 15 minutes. Thank you.
I'll give myself that challenge. And thank you very much.
If you go for 20, don't worry. If you go for 25, don't worry. This is a woman-led organisation. Just do whatever you want. Go for it.
Thank you. Thank you. That's really, really lovely of you. So thank you, and most particularly thank you for the invitation to speak, and in fact to become connected to the Digital Law Association. As you know, I'm joining this event from Sydney, and I acknowledge the Gadigal people of the Eora Nation, on whose lands I'm meeting with you tonight, and I acknowledge and respect their elders past, present and emerging. In The Growth of the Law by Justice Benjamin Cardozo, he said, existing rules and principles can give us our present location, our bearings, our latitude and longitude. The inn that shelters for the night, though, is not the journey's end. The law, like the traveller, must be ready for the morrow. It must have a principle of growth. The Digital Law Association's vision for promoting a fairer, more inclusive and democratic voice at the intersection of law and technology is, I have to say, a brilliant one. one which will be achieved through the professional excellence of all of you and of all its members engaging at the forefront of digital law. But as women in law, we know that we have to be more than ready. For reasons which still confound me, a woman's life in the law can still be bound in by assumptions made by others. And those assumptions do not automatically operate for our benefit. At an institutional, and indeed at many levels, steps are being taken to remedy this. Increasingly, organisations in Australia and overseas, especially in the United Kingdom, are mining the data on female briefing rates, female retention rates, female participation rates in those areas of work that are most sought after. This is essential because we are, that is, the collection of data, the mining of the data, is essential because we are in an era where data is respected and provides little opportunity for counter-argument, provided, of course, that the data is well-based and is representative of what it is intended to demonstrate. There is also increasingly work being done on attitudinal behaviour which inhibits the advancement of women in the way and to the extent that women, by their talent and by their experience, should be recognised. All lawyers must, in Cardozo's words, be ready for the morrow. However, experience has taught me that being ready for the morrow is all too often not sufficient when it comes to participation in those areas of law that we want, in which we wish to practice. Being ready does not automatically give you a voice. And if you don't have a voice, you won't be heard. It's as simple as that. But the voice that is heard has to be a professional and expert voice. Nothing less will be, nor should be, good enough. And the genius of the formation of the Digital Law Association is to provide the forum for the expert voice, a platform where expertise will be showcased, an important port of call for those who need the assistance of a good lawyer in matters digital. A forum which is available to all lawyers, male and female, but one which of course is designed to promote and support women in the field. I'm going to venture very briefly into the law surrounding this digital field. I suspect I will get many pop-ups on the chat box saying I don't necessarily have this one right, but let me just give you a few reflections on it. My last foray into speaking on emerging technologies and digital law was in 2016. I said to a participant at that forum that it seemed to me that you either had to become legally educated in the digital space or you had to let it pass you by altogether. The latter is an option, I suppose, because on one view, you might think that there are many aspects of the law that don't have any digital involvement, or at least not necessarily so. However, I think on reflection, it really isn't an option. As the world around us becomes increasingly digitized and or digitally controlled. Take a motor vehicle accident, for example. A motor vehicle accident may occur because the driver drove too fast or a pedestrian didn't look where they were going. But cars these days are nearly all computerized, and they will, at some time in the future, and in most of our lifetimes, even my lifetime, become driverless. And pedestrian traffics will become automated, and already are. During COVID in Sydney, there was a whole section of the CBD where the traffic lights were automated for pedestrians, and our movements will be mapped. I don't need to go further to explain why, therefore, all lawyers will have to be highly digitally literate, regardless of the area of practice. And I also believe that digital law will become a discipline of its own if it isn't already. If I go back again 4 years ago when I was first looking at this question, blockchain technology was being promoted as a possible replacement for the ASX Clearinghouse's Electronic Super Register System, or CHESS. Today, the ASX, only 4 years later, the ASX are working speedily towards implementing blockchain technology in their CHESS replacement, a shared replicated ledger of transactions and a distributed database synchronization, replacing a centralized administrator and data stores with a greater level of accuracy and security for all parties. This timeline for the replacement, like most projects, has been extended as a result of COVID-19, but in real terms, it is essentially upon us. That's just one example. The potential applications for blockchain technology are numerous and possibly innumerable. One fairly straightforward example is in tracing and certifying the sustainable provenance of retail products. In recent years, the risks that complex and unmonitored supply chains hold for human rights violations have become increasingly apparent. Modern slavery, where multiple subcontracting entities are engaged across a series of jurisdictions with varying levels of understanding as to their employment conditions, is one of the known and more widespread of these human rights violations. It is the known but faceless side of consumer consumption. The transparency of blockchain, in its capacity to be a public ledger of a product's development from genesis to consumption, is therefore welcome in this world where physical connection, not only between the beginning and the end of the supply chain, but at many points along the way, is absent. Further examples of blockchain's potential include its use as an anti-counterfeiting tool, allowing the tracking and verification of products such as pharmaceuticals and luxury goods, and to combat fraud and track provenance in many industries, including the diamond industry. When I first looked at blockchain back in 2016, the first question that came to my mind was, what was its legal character? And casting my mind to the law on the sale of goods, from its origins in the Law Merchant and Sir Mackenzie Chalmers' Sale of Goods Act of 1893, that law, the law of sale of goods, has always been fundamentally concerned with the recording and passage of title, with the verification of the goods according to their promised description, and with the combating of fraud. It requires, I suggested then, no great stretch of the imagination to conceive the incorporation or the accommodation of blockchain technology in this legal context. Section 22(1) of the Sale of Goods Act New South Wales, for example, recognises, consonant with freedom of contract, that in the sale of specific or ascertained goods, title will transfer to the buyer at such time as the parties to the contract intend it to be transferred. It would seem entirely plausible, therefore, for parties to a blockchain transaction to fix their intention as to transfer of title by reference to the entry of an event or transaction on a blockchain. Likewise, in relation to the sale of unascertained goods or future goods by description, and the application of Rule 5 of Section 23 of the Sale of Goods Act, it seems entirely plausible that the requisite unconditional appropriation of goods to the contract could take the form of a blockchain ledger event. Distributed autonomous organisations, or DAOs, are another fascinating application of blockchain technology and smart contracting. In this structure, like-minded individuals with a common goal or purpose contribute funds to an autonomous organisation, which then pursues the desired purpose or venture in accordance with the rules and procedures which have been programmed. The smart contracts expressed in the organisation's self-executing software and held by blockchains become the unifying structure of the entity, determining its directions and its parameters, with members akin to shareholders holding social, that is voting rights or patrimonial rights, and receiving a portion of the organisation's capital. Now we know that the first DAO, which was simply named DAO, launched in 2016, had over 11,000 investors contributing in US dollars $150 million worth of Ether over the course of a single month. But by June, in fact the 17th of June that year, a loophole in the DAO's smart contracts resulted in a hacker gaining control of over 1/3 of the Ether, and the entity failed as a result. My reference to the law of the sale of goods may seem naive, and the collapse of the first DAO might now be an interesting but not unexpected historical event, as often occurs with new technology. But I still have to ask the question, what is the legal character of this new thing that we are dealing with? Now, we know that DAO wasn't a corporation, and it isn't a corporation, it couldn't be. For example, because in Australian law, about which I'm speaking, Section 117, subsection 2 of our Corporations Act requires that applications for a corporation's registration must contain details of each person who consents to becoming a director. Without registered officers, without directors, and without employees, DAOs do not constitute a corporation and therefore do not have that legal personality. Do they give rise to a partnership or to a joint venture? Now that's an important question because the relationship between partners and joint venturers is quite distinct. Looking simply at the fiduciary obligations attached to those legal structures, partnerships are a recognised category of a fiduciary relationship, and partners will thus owe each other strict fiduciary obligations. On the other hand, a joint venture will not usually involve fiduciary obligations, absent something special in the joint venture agreement or the nature of the relationship between the parties. The answer may be that a DAO is a sui generis entity, the functions and operability of which are facilitated by smart contracts. And it's been estimated that 30 to 50% of human activity could be automated by 2035 if technical progress, costs, social and regulatory spheres align. That's just an amateur's initial take on what could be some of the problems as we engage in this digital world from a legal perspective. In May 2019, if I can move forward a little, the Australian Computer Society produced a technical white paper entitled Blockchain Challenges for Australia. It identified 4 challenges: scalability, security, regulation, and education and employment. And the authors suggested that these challenges were important as blockchain promised to reshape the Australian economy and would significantly impact on the way business was done in Australia. And in their 2019 book, entitled Blockchains, Smart Contracts, DAOs and the Law, Krauss, Obrist and Hari identified 3 principal challenges: the regulatory challenge, the environmental challenge, and the governance challenge. Included in both the security challenge identified by the ACS and the governance challenge identified by the authors of the book to which I've just referred are questions of privacy and data protection. In other words, there seems to be a crossover between these two. This must particularly be so in an era where data protection is a critical national and international strategic issue. And with permission, I'll just say these few words on these 2 issues before concluding. There is significant complexity in navigating compliance between blockchain structure, this decentralized, immutable, transparent, and distributed capacity, and the protection of privacy and the personal data under the Privacy Act 1988, the Australian Act. Now, whilst not every piece of information uploaded onto blockchain is personal data, many documents and many aspects, many pieces of information, particularly relating to financial transactions, are. In the EU's General Data Protection Regulation, there is a clarification of the rights of individuals to access personal data held by a controller, namely a right to access, a right to rectification, and a right to erasure. Erasure, that is, the right to have information erased, which is colloquially referred to as the right to be forgotten. And these personal data rights have been upheld by the European Court of Justice in 2 cases involving Google, one in 2014, found in favour of a Spanish citizen, and the second, a case from last year, 2019, which upheld these rights to personal data under the GDPR. So it seems to me that this is an area of interaction, financial, personal, which is going to affect everything that we do at every level. If that is so, and if the role of the lawyer is to engage with those aspects of society, which is all aspects of society, as they come across your desk, it seems to me that as lawyers, there will be actually no choice but to be digitally literate and legally literate in a digital world. So once again, I would just simply congratulate the Digital Law Association on creating what should be a very vibrant, but as importantly, a vital forum where one can gain information, exchange information, and become educated. So congratulations once again. Thank you.
Thank you, Her Excellency. We're really honoured to have you join us this evening. That was really interesting insight into both your experience in coming to the sort of new world of these new technologies and how you considered them, and also highlighting some of the real challenges that the female gender does face. And I think what's interesting is that something that I think the female gender does have that is to our advantage is a real collaborative nature, and I think that all of us that have been involved in bringing this event together tonight, and you know, we had over 400 people register, and as Natasha mentioned, we really only kicked this off a few weeks ago, just shows that there really is a big demand for women to have opportunities where both law and digital technology collide. So thank you very much, Her Excellency. We're very, very honoured and pleased that you could join us. Thank you. So now turning to our next speaker.
Am I also allowed to say that is a fabulous jacket?
Oh.
Okay, you could go to the next speaker.
Anna Lazinski is an Executive General Counsel and author. She believes that legal innovation is invigorating, change is energising, and efficiency will never go out of fashion. Anna has studied law in Melbourne, Beijing, Utrecht, and Boston. Starting out at a major Australian law firm, she spent the majority of her legal career in-house working in the banking, automotive, and cosmetics industries. Described as a change agent, Anna is a sought-after commentator and speaker both domestically and internationally, seeking to shift the dialogue in order to propel the profession forward. Anna has produced and authored a number of resources, including her ebooks, Legally Innovative and The New Age Lawyers, and other materials, including a Mindset Hacks Guide, a playbook for working with legal tech vendors, and tips for innovation success. Please join me in welcoming Anna Lazinski.
Thank you, Her Excellency, for your insights and for the reminder about using our voices. That really resonated with me. And thank you also for that introduction. It's a privilege to be speaking at this exciting launch this evening. Congratulations to the DLA on this milestone. Before the pandemic, Jean-Paul Agon, the CEO of the L'Oréal Group, remarked that L'Oréal has been changing more in the past 5 years than in the last 35. Indeed, the clock of the 111-year-old beauty giant with an existing portfolio of 36 brands ticks faster than most. In the past 5 years, L'Oreal has staged a digital revolution of the beauty industry, creating a new generation of products and partnerships, harnessing technology, artificial intelligence, and data to deliver personalisation to its end consumer. For L'Oreal internally, its prior investment in building a 1,600 employee digital team and delivering digital training to 33,000 staff around the globe has paid off during these unprecedented times. L'Oreal's global e-commerce sales, being 5% of its total sales in 2015, has jumped to 25% in 2020. A crisis does not create a whole new trend at its own discretion. It only accelerates the existing trends. It serves as a chance for companies and legal functions who have been turning their mind to the future to test what they've been working on. According to recent legal research by Gartner of 97 global general counsel, those existing trends are as follows. Digital capabilities pervading all aspects of business. Data savviness, literacy and governance. Self-service as a staple option. Speed of problem solving. And a fragmentation of the regulatory framework as politicians drive more assertive local agendas. Thankfully, it didn't take a crisis for the L'Oreal Australia and New Zealand legal team to turn its mind to the future. Over the last 5 years, we too have changed a lot. We are proudly pioneers of new age lawyering within L'Oreal globally. Before I touch on that transformation journey as a case study, I wanted to set the team scene. We are a team of 3 problem solvers, supporting 30 brands in Australia and 20 brands in New Zealand, as well as corporate functions. Year to date, 2020, we've completed 1,400 matters, averaging 150 new matters a month. 81% of our focus is on the Australian jurisdiction. 50% of our matters relate to sales, marketing, e-commerce, digital, CRM, and consumer insights. 5% of our time is spent on legal education and training, having already delivered 24 legal sessions year to date across Australia and New Zealand. Our transformation journey has allowed us to learn in new and unimaginable ways. Here's how we've collaborated with our business colleagues. Over the years, we have developed a range of self-service apps to automate routine tasks such as NDAs, promotions T's and C's, influencer agreements, supply agreements, employment agreements, and customer agreements. We currently have 15 self-service legal apps available 24/7, with more on the roadmap. In the month of August, 379 legal transactions took place on our tech platform, mostly without legal touch. We have enjoyed electronic approvals, signatures, and storage of contracts well before COVID. We provide automated advice on independent contractor regulations and privacy assessments. Our lawyers get on-the-job training around change and project management, legal operations, and having a growth mindset. We are constantly experimenting, at the moment with chatbots and artificial intelligence contract review. We also use legal matter management software, knowing that data is the new oil and the next big must-have for a legal team. This acute and consistent focus on our legal services delivery has resulted in thousands of legal tasks at L'Oreal ANZ being automated at a fraction of the cost and time they previously required. It's dramatically changed the perception of the legal function and freed up its talented lawyers to spend 70% on complex problem solving of medium to high strategic importance. We have changed the way legal risk is managed by working collaboratively with the executive team to define the business's risk appetite and what's strategically important. recognizing that working harder is not the answer for well-being or productivity. It's allowed us to transition seamlessly into this full-time virtual world when business demands more speed and agility. In the last 3 years, we've also saved the business $9 million in time and material dollar savings versus those legal tasks being done by a human, internally or externally. Did I mention we're a little bit obsessed with data? Because if you can't measure it, you can't see it. While our matter management tech is not as predictive as we'd like, we work with data daily and use insights to inform our capacity, effort, productivity, and the way that we talk with our various stakeholders. As a team, we also closely monitor our legal supplier mix, selecting providers who speak the same language as us to optimize our performance. That extended legal team, as we call them, spans new law and big law firms, as well as tech providers. And to dispel the famous fear that the robots are taking over, while our spend on technology is higher than it is on external law firms, this is not at the cost of human jobs. To complement our transformation journey, our human legal capital has increased by 400%. In 2017, that is 3 years ago, Mark Cuban, tech entrepreneur, said that artificial intelligence, deep learning, machine learning, whatever you're doing, if you don't understand it, learn it. Because otherwise you're going to be a dinosaur within 3 years. In other words, the future has already arrived. It's just not evenly distributed yet. In my mind, the lawyer of the future, or if I'm going to be a little bit provocative, the lawyer of today, must have a trifecta of intelligences. The TQ, the technical, the EQ, the emotional, and what I call IQ 2.0, innovation intelligence. And building that innovation intelligence capability starts with mindset. According to a recent Harvard Business Review article on open innovation, often the biggest barrier to successful open innovation is simply the reticence to commit to it. Today, there are still too few legal functions changing the status quo by truly prioritising innovation and transformation. Many are still occupying the year 2000 company lawyer mindset versus the era of running a scalable and business-minded legal function of today. Some still exist without any technology. According to recent Plexus research, 98% of general counsel rated transformation as critical to their future success, yet only 27% are at implementation stage. We all know that actions speak louder than words. Similarly, the 2019 ACC Australia benchmarking report confirms that the legal profession still remains more old than new. For example, reducing outside counsel spend was identified as the top priority. Employing technology to streamline processes and reduce time spent on low-value work was rated as moderately important. And 22% of respondents rated the employment of technology as low priority. Gartner, in its latest research, has identified 5 shifts for legal to succeed into the future. The first is around value drivers, from cost and quality first to agile strategic support. Shifting legal's role from legal services manager to enterprise capacity builder. Changing the business role from centralised legal control to business partner ownership. Shifting the delivery model from direct services to in-channel product delivery, meaning embedding scalable legal products to promote standardisation and automation. And finally, it's changing the way that we use our resources from the law firm relationship model to having flexible provider networks. Charles Darwin once said, "It is not the strongest of the species that survives, nor the most intelligent. It is the one that is most adaptable to change." The business of legal is just starting to turn into an innovation have and have not world. Those who can harness the powerful combination that is humans and computers, and those who cannot or won't. Innovation intelligence will sooner than we think define a lawyer's relevance and in time, reverence. The future of modernising the legal profession and the delivery of legal services needs your support now more than ever. It needs you to take the baton, be adaptable and join this incredible transformation race. Let's not slip into old ways, even when business returns to some version of normal. Instead, let's plan a new future, one that addresses the 5 shifts that I mentioned, where innovation is second nature to every lawyer and law student, and business as usual for a legal department, part of our duty, as Natasha said. Let's make sure we use COVID as a catalyst for greater change, to change more in the next 5 years than in the last 35. In conclusion, I would like to quote the words of Mark Zuckerberg, who I know is a little bit unpopular at the moment, and even more so if you've watched The Social Dilemma on Netflix. But his words go to the essence of what I understand the DLA is all about. Let's do big things, not only to create progress, but to create purpose. Why? Because the future of the legal profession is worth it. Congratulations and thank you.
Thank you, Anna, for that inspiring talk. During our preparations for this event, our communications portfolio lead, Jenna Adamson, said, "I've never been more empowered in my career than under Anna's leadership." And I think her words today epitomise why. It now gives me great pleasure to introduce Dr. Julia Powles, who is an Associate Professor of Law and Technology and is also the Director of the newly established Minduru Law and Tech Lab here at the University of Western Australia. It's the headquarters of a bold worldwide network, futuresays.org, which is aimed at tackling lawlessness in the tech ecosystem. Julia is an expert on technology law and policy who leads research on digital rights, internet governance, and the law and politics of data automation and artificial intelligence. Her CV is both extensive and impressive. As a snapshot, Julia returned to Australia early last year following more than a decade in the US and Europe, where she held academic appointments at New York University, Cornell University, and the University of Cambridge, where she obtained her PhD. She also worked as a United Nations speechwriter, a technology editor and columnist for The Guardian, The Wired, and The New Yorker. In 2018, she was the Council of Europe's Rapporteur on Human Rights Implications of Algorithmic Systems and the Poynter Fellow at Yale University, researching artificial intelligence and power. Now, despite these credentials, if you ask Julia for a biography, she'll tell you to introduce her as someone recovering from being in a bar fight with Google for the last 10 years. And so with that said, and with a mandate to be provocative, here is the bar brawler, Julia Powles.
Thank you very much, Jackie, for that welcome. And great to be here this evening. I'm conscious I'm between you and a breakout room, so I'll be relatively brief this evening. I wanted to respond to the ambition of the Digital Law Association to become a catalytic piece of digital infrastructure for promoting a fairer, more inclusive, democratic voice at the intersection of law and technology. And the association has identified as 2 priorities in achieving this ambition: to promote female authored publications relating to law and technology, and to create a platform for more female voices. And as a first provocation, I would note that every quote tonight has been from a man. And it's an interesting thing how much that is part of our, I think, invisible bias in how we reference things culturally. And so the point I'd like to make tonight is around the many women, people of colour, LGBTQ+, and Indigenous scholars, activists, and organisers that have given voice to a vision for a fairer, more democratic and inclusive technological ecosystem for well over 3 decades. And one of my points of wariness about this surge that Natasha described about COVID and digitisation is that this critical perspective on technology has not hit the legal mainstream. And law is, in many ways, another vehicle of power. And one of the claims of the author Julie Cohen, a really leading tech critic from Georgetown Law School, is that the law has been weaponized in many ways by the tech industry, which now has the most influential companies in the world, and they are companies like Google, Facebook, Amazon and the like. And a catalytic piece of infrastructure, I think, if the DLA is to be one, really needs to take seriously these voices and critiques. And so I'm going to highlight some of those women today, and I might do it through, in the first instance, this film that was referred to. I don't know if there's any slides that can pop up, that was referred to just previously, just back to the previous slide, of The Social Dilemma. And this is a film that all my friends and relatives seem to be watching right now. And the cliff notes on the film are that it is a redemption tale for the men, and they are all men, of Silicon Valley who got us into a digital extractive economy where everything we do online is tracked and traded, no matter the consequences for our health, our children, or our democracy. And thinking about this story of the men who built digital platforms that are now undermining democracy led me to an analogy that I think is another piece of powerful infrastructure that this association could learn from. Mothers of Invention is a wonderful podcast, if I can go to the next slide, by two inspiring women, the former Irish President Mary Robinson and the comedian Maeve Higgins. Mary and Maeve's subject is Our Frying Planet. And the strapline of their wonderful podcast that I commend to you all is that while climate change is a man-made problem, it has a feminist solution. They are at pains, of course, to say that a feminist solution isn't only about women, but it is about organising, reading, listening to, and building with women. And I think it's also the case with digital platforms that we have a man-made problem, coined, as I've seen in the chat, a number of people are fans of Shoshana Zuboff, who's worked in this for over 4 decades. Surveillance capitalism is a man-made problem, and it has a distinctly feminist solution. The money quote in The Social Dilemma is a quote from Sean Parker, who's the first president of Facebook, and it echoes a film that many will know, The Social Network, which sort of is iconic in our memory of Facebook. And Sean Parker is a fairly unlikable character, but he says something that I think crystallises the challenge in The Social Dilemma, and also why we need a different way of solving it. He said the thought process that went into building these apps, Facebook being the first of them, was all about exploiting a vulnerability in human psychology. The inventors, creators, that's me, that's Mark Zuckerberg, it's Kevin Systrom of Instagram, it's all these people. They understood consciously that they were exploiting vulnerabilities in human psychology, and we did it anyway. Women have sounded the alarm on men developing tech in this fashion for well over 30 years. Shoshana Zuboff's In the Age of the Smart Machine was written in 1988, while Batya Friedman and Helen Nissenbaum wrote about the challenges of bias in computer systems in 1996. Now very popular around this whole conversation around AI ethics. And if you want to know the story of The Social Dilemma, I recommend these 3 fantastic books, all of which were erased from the intellectual legacy of the film The Social Dilemma. One is Algorithms of Oppression by Sophia Noble. Another brilliant book by Natasha Schull is Addiction by Design, about how the tech of today is engineered to be seductive and to take us away from our main objectives. And then there's The Magisterial Age of Surveillance Capitalism by Shoshana Zuboff. There's also a brilliant TED Talk by Carol Cadwalladr, who broke the Cambridge Analytica story. And finally, for a blazing critique of the film's central figure, Tristan Harris, I recommend Irish writer Maria Farrell's piece, The Prodigal Tech Bro. I raise all these points because it is absolutely crucial, I think, that we see the work of colleagues and peers who work with those who are affected by technology. And one of the first I recommend here is by Lily Irani. I know many in the legal app space and legal tech space are considering law apps. I implore you to consider the whole philosophy of design thinking and the way that it provides very limited solutions to traditionally marginalised populations. Her piece in Catalyst is a masterwork. My colleague at UWA, Amberlyn Kwai-Mulliner, has a tremendous new work out called Living on Stolen Land, and it challenges us all in future thinking. She's very much a scholar of futurisms, to consider deep Indigenous histories and perspectives. Ellen Broad is a tremendous young Australian who's written a wonderful book on the AI condition, very accessible work. She's a lawyer working in now at 3AI in Canberra. Probably my favourite of the works on this page is a new work by Julie Cohen, absolutely brilliant piece on Between Truth and Power. And finally, I'd recommend 3 scholars from Europe. Marae Hildebrandt is a computer scientist and a lawyer and a philosopher. She is absolutely incredible, and she has some brilliant works, including an introduction to computer science for lawyers and her brilliant piece, Smart Technologies and the End of Law. And finally, 2 great Europeans. Orla Linsky has a wonderful book on data protection law that considers the human rights foundations of it, and Angela Daly, who spent a good amount of time in Australia on private power and the major tech platforms. So I just wanted to bring those in. I, along with Jackie, am leading the tech portfolio of the Digital Law Association. I will happily jump on the bandwagon of the book club. I think there is so much tremendous work to do, and I really just wanted to add my piece to complicate the story of digital technology and the enthusiastic adoption of it, because I think the opportunity for a female-led group is to think of a distinctively female and traditionally marginalised perspective. And that would mean not taking the same route as the men who got us into this current digital situation in the first place. Thanks very much for the opportunity.
Thank you, Julia. And I was about to get on and say how we were going to rally you to host the first book club, but I think you've already volunteered yourself.
You're on mute,
so that
Sarah.
I can hear you.
Julia. Can you hear me? Yeah, great. Thank you, Julia. I was just saying that I was about to get online and rally you to host the first book club, but I think you've just volunteered yourself. So thank you very much for that. That was really, really interesting, really inspiring. You obviously didn't get a chance to see the chat that was going on while you were speaking. So there's some amazing comments and shout outs and recommendations going through there. And as I just mentioned on the chat, we will circulate some slides as well as all the gold that's filtered through the chat to you in the next couple of days, to all of you in the next couple of days. If you get a chance, Julia has published some really interesting and publications on some really complex issues, really interesting. And so if you get a chance to jump onto the UWA website and check that out, that is great. We are really honoured to have Julia and Jacqueline as our tech leads. I think that everybody can see tonight just how many really experienced and expert people, that subject matter experts that we have in this group. And I think that really hits on the expert point that her excellent. We are just about to move everybody into the breakout rooms. We're going to have one last shot at the video. We've got one last, chance. We're not going to let technology be the winner tonight. Before we do, so as we get the video up and running, we are going to go into breakout rooms. Most people had registered their preferences for the breakout room beforehand, and so you will receive your preference. If you did not get a chance to register on Eventbrite, you'll be randomly allocated to a room. Just leave the room and jump back into the main room if you prefer a different breakout session, and we'll see what we can do, numbers pending. I'd like to give a big shout out to Phil Turner from Nexel. Nexel are hosting the event tonight. Phil's done a great job of just giving us all the tips and tricks on how to launch such a big event. We've got a huge number of people online, and other than the video, everything's gone very swimmingly. So thank you very much, Phil. We really appreciate it. And if you haven't checked out Nexil, it's a global network for lawyers, for networking, referrals, and sort of collaboration. So fits nicely with what we're trying to do as well. Just see if we can get that video going. Yeah, we've got sound. Great. Thanks, Joni.
Is that I will no longer spend any time on low-value repetitive tasks, and instead my job will focus on complex and strategic matters where I can add the most value to my organisation. Digital technology and their implications for the law are increasingly pervasive.
The rapid shift nationally and internationally to digital-first economies has enormous implications for us all.
We'll see laws become more pervasive in all aspects of society as technologies, and in particular data, have more and more subject touch points.
How does everything from the most cutting-edge AI and blockchain solutions that our clients prepare, people going digital for the first time,
shaping legal policy and frameworks in order to deal with the advancements in technology.
Exploring opportunities to create, commercialise and comment on technological changes within the practice of law, inspiring the next generation of legal professionals.
It's exciting to be part of an organisation such as the Digital Law Association, which promotes inclusive innovation within the legal sector.
We need the Digital Law Association because data and experience tells us that diversity and inclusion doesn't just happen, we need to make it happen.
The big questions of equity, ethics and governance in digital technologies should not be left to a small group of experts.
It's so important to ensure that we meet the oncoming challenges of AI and digitalisation in a way that represents all society.
To make sure that women don't lose the advances they have made by being subject to discriminatory hiring practices all over again.
The Digital Law Association is well placed to foster collaboration and build a platform for female voices who have unique and deep insights into the legal and regulatory issues in this space.
The Digital Law Association is important because it provides women with the opportunity to innovate and lead in this important technological space. We love the legal.
Just before we jump into our breakout sessions, we just want to give a huge shout out to a number of people that came together to make this event happen tonight. As you can see, there are a number of volunteers there on the slide. Some of them are founders, portfolio leads, and just people that have come together and shown an interest in what we're trying to do. There's probably another slide again, so if we've missed anybody, apologies, but we just want to appreciate everybody that has put an effort in, and there has been a huge effort in putting together tonight. Okay, so we're going to send you all out now to the breakout rooms. And as I mentioned, just message Joni, Sarah or Phil in the chat. Leave the room, jump back in the main room if you'd prefer to go to another breakout. We've got smart and legal contracts with Ariane Garside. We've got how and should technology, you can read that yourself now, thanks Joni. So they're our 6 breakout sessions. They're all fabulous. We've got some amazing people taking those, as well as some great people attending. So just hold for a few moments and we'll send you into those rooms. Thank you.